Mr. Vice President, I thank you for the opportunity to contribute to the bill that appears before us today. You know, I want to take this opportunity, Mr. Vice President, to particularly speak to the population and the people of Trinidad and Tobago, as I, of course, stand by the government in support of this bill. Now, laws are not static, as we are aware. Laws are very dynamic. And it is my personal belief, Mr. Vice President, that we will be failing miserably as legislators if we adopt a strictly conservative approach when drafting laws. And this is, of course, my personal opinion. Mr. Vice President, it is also my view that offences such as revenge pornography, which is dealt with in Clause 5 of this bill, does not only try to shame women, but what it does, Mr. Vice President, is that it also tries to silence women. And as responsible legislators, it is, of course, our responsibility to stand against this. Mr. Vice President, to my mind, consent is what happens when you give permission. Theft and assaults are acts which happens when people take it from you despite saying no. So, for example, Mr. Vice President, a young lady has taken a nude photo and she has chosen who gets to see them. So yes, that is the fact. But I submit that this action does not make that young lady a fool. And that action does not mean that that young lady is asking for trouble or is deserving of an assault. Especially when we examine, Mr. Vice President, sometimes the circumstances and the context in which certain photos and images may be shared by a young woman, especially in a romantic relationship. And this is one of the fundamental reasons, Mr. Vice President, why I stand in support of the criminalization of voyeurism, the criminalization of what we have termed in the Senate today as revenge pornography. Women are not to be silenced. Women are not to be blackmailed by decisions that they took relative to sharing photos and sharing videos in confidence. And we stand in support of protecting vulnerable women. Mr. Vice President, what I want to do before I get into the crux of my presentation, to this end, I want to join with the Honourable Attorney General and, of course, put on the public record a sincere thanks and appreciation to our young, our dynamic, out-of-the-box thinking attorneys of the Criminal Justice Unit of the Office of the Attorney General and the Ministry of Legal Affairs. To the CJU unit, I respectfully say, and I place on the record, you certainly understood the assignment. And this bill, of course, is in its embryonic stage, but it is the beginning of something that I am certain that if we work together as a Senate, we can produce something that we will all be proud of. Madam President, I heard the comment being made by the Honourable Senator John relative to consultation, and I can say I also know that the Attorney General, in his piloting of the bill, he would have focused on the numerous stakeholders whom the Office of the Attorney General would have written to during the preparation of this particular bill. What I would also like to add is that a national survey was also conducted by the Office of the Attorney General, and there was wide feedback. Now, this survey ran from May 26 to November 26, 2021. And what I actually have in my hand is the survey report. The results of this survey is also still present on our social media pages, and anyone who may be interested in having a look, it is there. So, and this is just for me to clear the air on the point being suggested that, again, we have come to this parliament without consultation and presenting a law. This is furthest from the truth. So we would have written to key stakeholders, those who were interested. They chose to write and respond to us. And then we would have also made a conservative, a sincere attempt to reach out to the members of the public by that survey that was available to the public for the duration of the 26th of May to November 26, 2021, in which we were able to solicit the views and the opinions of the public. So just to clear the record on that point, Madam President, it is furthest from the truth to even suggest that we have come to this Parliament with a legislation in the absence of consultation. Now, Madam President, before I get into the crux of my debate, my contribution, and my contribution is, at least if I set out what I hope to achieve today in my contribution, I would try to look at the practical aspect of compensation. And this is, of course, for the benefit of the listening public and how compensation would work and what would be operating within the court's mind when granting compensation in a matter such as this. But before I do that, Madam President, I want to address address some concerns that, of course, were raised by my colleagues in their individual presentations. Now, if I could firstly turn to the Honourable Senator Lakshmi Dayal, I recall noting in her contribution, she made the point, she was speaking of the Honourable Senator spoke about legal proceedings. And she indicated that legal proceedings would include, and this is her words, I'm concerned whether family law proceedings such as divorce will be captured here. She would like to hear if we had a view on family law proceedings, not involving children, but for matrimonial proceedings, if there will be an if there'll be a provision, for matrimonial proceedings. Now, Madam President, the reason why I want to spend some time looking at legal proceedings and the protection that is provided for evidence that is led in legal proceedings, especially matters that are sensitive like this, like those offences that are created in the bill that appears before us, is simply because oftentimes, remember, the purpose of us introducing this bill and this legislation is so that victims of this offense are encouraged. They're encouraged to go to the court and to bring a claim, or they're encouraged to go to the court so that we can have a successful prosecution of offenders. However, if the man on the street or a vulnerable person is fearful that by instituting legal proceedings, the candle is going to cost more than the funeral, and by that, I'm referring to not the cost of the proceedings, but I'm referring to then all my business is going to be out there on the road. What you may actually have, if that is the perception of the public, what we may actually have is that even though we create good law, persons may actually be afraid to still use the law and the remedies of the law that are available. And this is at this point, Madam President, and of course for the benefit of the public, I want to look at protection for evidence that is provided in other pieces of law, so that those who may, if and when, and of course when this law is passed after the select committee stage and so on, that the members of the public can rest assured that at least evidence will be evidence and information. There's a layer of protection that is provided by the law as it relates to these matters. Now, the Attorney General and several of my colleagues in the Senate would have looked at the Lyndall Simmons case. And the Lyndall Simmons case, of course, it was taken in a civil arena. But in that very case, the dicta that came, and this of course addresses also the concern, and I'll get back to Senator Lakshmi Dayal's point and question about matrimonial proceedings, but I'm starting looking at civil proceedings. In this particular case of Lyndall Simmons, the dicta that came out of that case, I recall, Justice Frank C. Prasad, he ordered, and I could read from the actual judgment, from the case, he ordered that all photographs, exhibits in the matter be placed in a sealed envelope until the limited time for filing of an appeal. Upon the expiration of same, if no appeal has been filed, the photographs are to be destroyed by the registrar. If appeals are filed, the photographs shall remain sealed until any further order is issued by the appellate court. And I'm saying this, as I said before, for the benefit of the listening and viewing public. So what the Honourable Judge in this matter did is that he is what practitioners of the law like myself, we call sealed the proceedings. And sealing the proceedings is that the evidence in that proceeding is actually sealed so that there's a layoff and it's kept by the Registrar General, so that is an effort to protect, of course, pictures, to protect evidence from entering into the public domain. So, for example, in matters like the Lyndall Simmons case, there would have, of course, been photos, all kinds of photos. And, of course, a person pursuing this matter, the inherent fear is, okay, I go to court with this matter, the court staff has access to it, and then eventually there's a leak into the public. A court has the jurisdiction from the civil standpoint that they can, a judge can order that these proceedings are sealed. And that is a layer of protection that while there's no specific rule in the civil court, it has been a long-standing practice. And even if we revert to Rule 1.1 of the CPR, which is the overriding objectives and so on of the CPR, the court has to deal with matters, of course, in a fair manner. And that is by sealing proceedings, of course. It's one way in which the general public can be rest assured. Do not be afraid if and when this legislation comes into being. Do not be afraid to evoke the jurisdiction of the court, because it is only when you do that you can take a stand and we can bring an end to these perpetrators. Now, so that is from the civil point of view. Now, the bill that appears before us, on the other hand, Mr. Vice President, what it does is that it criminalizes, we all know that, it's different from the civil threshold because it criminalizes voyeurism, revenge porn. And the question now is whether in a criminal setting, if I have decided, if I am a victim of revenge pornography, if I am a victim of voyeurism, if I decide to pursue this matter, and I'm now a VC, a virtual complainant in this matter, what layer of protection am I provided with? And layer protection, again, is as it relates to the evidence, as it relates to the public having access to the evidence that is led in that matter. And I'm saying this especially because I was a practitioner for many years, and that is usually one of the fundamental fear of a VC in a matter, that I decide to pursue this matter, and I made reference to it already, that I just don't want my business out there, and I don't want my photos being leaked by a court in legal proceedings. So to the members of the public, as we look at the criminal law now, this is where we look at the interoperability of law arguments with this bill that we have and the criminal proceeding rules. In the criminal proceeding rules, Madam President, there is particularly Rule 14.2. And this Rule 14.2, again, in criminal proceedings, it deals with the sealing of proceedings. And this is very critical, and the rule actually states that the prosecution shall disclose material under Rule 14.1b unless the magistrate or judge orders that such material should not be disclosed in the public interest. So for those, even if you have criminal matters in which this evidence is given and you're fearful, a VC is fearful that, oh my God, my information may be leaked, an application can be made pursuant to the criminal proceeding rules, Madam Vice President, so that, Madam President, that the evidence and the matter itself can be sealed. And that is another layer of protection that is provided to the virtual complainants. And I cannot emphasize again, the reason why I'm taking the task of going through this is because I know For sure, if and when this law comes into being, there are going to be vulnerable young women, young children. There are going to be people who are still afraid to use the law. And I'm saying to you, do not be afraid. Do not be afraid, because it is only when you use the law and those provisions provided in the law, you will be protected, and we can bring an end to some of these monsters that exist in our society. Now, to answer the Honourable Senator Lakshmi Dayal, who focused on matrimonial proceedings, I had the benefit of course, practicing in the family court. And at the family court level, Madam Vice President, there is also that layer of protection for evidence and sensitive evidence that is provided. So, for example, if we look at, not for example, the law is, Madam President, Section 25 of the Family Law and Children's Act. This was a 2016. It was proclaimed on February 27, 2018. This also, that section, Section 25 of this law, what it does is that it allows for a family court, and I will read, it allows for a family court judge master to also seal a proceedings. Also, there's a restriction on the publication of proceedings involving children, which we are aware of. The court can order copies of a ruling to be redacted prior to publication. Similarly, it can seal the copies of transcripts and other relevant documents. This is within the discretion of the judge or the master of the court. And so, to answer the Honourable Senator's concern, I don't believe it was necessary in this bill that appears before us to actually prescribe a process whereby this evidence, a process for legal proceedings, because there are other areas of law that will protect evidence even in the family law arena, whether it's divorce, whether it's a matter involving a child. And as I said, I've placed on the record the parts of the Family Law Act that also provides that layer of protection for evidence, sensitive evidence that may be entered or may be adduced in a matter as evidence. And again, Madam President, as I said, and I know I may sound repetitive, but this is simply, I want the members of the public to understand that there was no need really, at least as it relates to legal proceedings, for us to go through the task of giving additional provisions to protect the evidence, because we have to bear in mind there is the criminal proceeding rules. We have to bear in mind that there's the Family Law Act. We have to bear in mind there's the civil proceeding rules, and all of this deals with this what we term in practice as sealing proceedings. So you can seal evidence, and sealing the evidence would, of course, it refers to protecting the evidence from entering into the public domain. And I respectfully believe that that this was critical, at least to the members of the public, to understand the layer of protection that is provided by the law. Now, the other areas of the law. Now, I know the Honourable Senator Lakshmi Dayal, she also spoke about whether or not, she questioned whether or not the police would have the ability, for example, to shut down the cybercrime unit, to shut down the sharing of images and all of that. And of course, that is a procedural point, and I agree there. With respect to it is, we have to make sure that there's an alignment, as the Attorney General always says, with the plant, machinery, people, processes, and the law. But the bill that appears before us also provides, apart from the police physically taking down images, the bill that appear before us in its current incarnation provides an injunctive remedy that can also be granted by the court. And that injunctive remedy is found in proposed Section 22D1B. And that is where the courts can actually then order the court can make an order that the defendant immediately takes down whatever images and all of that are provided. So yes, the police plays a part, and the cybercrime unit will play a part in whether they have the technology to shut down. But we are not here to discuss the police at this point. We're here to discuss the law that appears before us. And in the law that appears before us, we are giving the court, the judicial officer, the power to also grant an injunction, which will result in the immediate removal of these documents, of these any kind of sensitive evidence, these pictures and so on that would be shared on social media. So that was the extent of certain points that was raised by the Honourable Senator that I wanted to address. Now, Senator John, I know in her contribution, Senator John spoke about, she spoke about the necessity for sex and health education. And, she questioned the government on its position as it relates to sex and health education. And the reason why I want to address this is because I had the benefit of course, serving with my colleague, the Attorney General, in our recently Universal Periodic Review with the United Nations that dealt with human rights. And this was actually one of the major, this was something that in preparation for this Universal Periodic Review, I had the benefit of, having to read and bring myself up to speed with laws and our policy documents as it relates to sex and health education. Now, I agree that there is not a sex and health education curriculum in Trinidad and Tobago just yet. But what we do have is a health and family life curriculum in the Ministry of Education. Now, of course, there is a distinction between health and family life and sex education. I understand this. But the benefit I had in preparing for this Universal Periodic Review, when I myself questioned, why is it if we are moving towards modernizing laws, and I myself am an advocate of laws not being static and dynamic, laws not being static but rather dynamic, I myself would have questioned, but where are we at on introducing sex ed into school? And then you would think I would have remembered this because I was a teacher for umpteen years. One of the major challenges is with the consultative process and the stakeholders involved, because the education system, and let's not be blinded to that fact. We exist in a multi-diverse society, and in Trinidad and Tobago, for example, if you look at the education sector, we have different boards, the Hindu, the Muslim, the Presbyterian, Catholic, just to name a few. And if it is, we have to even look at the introduction of sex education into schools. That's a consultative process that is going to have to be exhausted. And more than that, you're going to have to get persons to be in alignment. You are going to have to get persons to look beyond traditional views and opinions and support such legislation or support such policy. And certainly I'm not expressing the view of the Ministry of Education at all, but this is just from a legal perspective. When I was preparing, as I said before, for the Universal Periodic Review, on that point as it relates to sex education. And I believe it was necessary to address it because, you see, I know the undertone of that again. That comment is as if we are just sitting idly as a government and we are not introducing legislation. So we bring a bill on voyeurism, but yet we have not done something as simple as sex education in school. And it is not a simple task. And that is what I wanted to address, the fact that these things, they require serious consultation. So that would have been the extent of certain comments made by my colleagues, Madam President, that I wanted to address. Madam President, if I may respectfully ask, how much time is full time? How much minutes? How much time have I got?
You finish at 3 minutes past 3.
Okay,
so about 6 minutes.
Thank you very much, Madam President. Now, I know I would now have to speed through my presentation, but as I said, my focus really now is on the compensation aspect. Now, Madam President, Again, the case of Lyndall Simmons, Teresa Ho and Lyndall Simmons, it is before it was spoken about already by the Attorney General. And yes, I know Senator Lachmi Diyal and the Honourable Attorney General went into some detail with this case. So, of course, to avoid tedious repetition, I wouldn't get into detail. We already know, and the Senate is aware, and the public is aware, that this is a civil matter. In the Lyndall Simmons case, however, the honorable judge, would have also focused on an Australian case, Giller and Prokopets, and in that case, he would have used that case would have spoken to what operates within the court's mind when assessing damages and when assessing compensation for a matter like this. Now, the Simmons case, as I would have earlier explained, and those before me, it is a civil case. The present law, on the other hand, that appears before us, Madam President, what we are looking at is that the redress that can now be found is in the criminal law. And of course, it can either be tried indictably or summarily. Now, despite this matter, Madam President, being heard summarily or indictably, the proposed Section 20 of this bill, Section 22, D of the bill, allows for an approach in that a person who has been convicted, a criminal court can then put on a civil hat and determine compensation in this matter, and can determine compensation, of course, for the VC in the matter.
Minister, you have 5 more minutes.
Thank you, Madam President. Now, I want to look at a very practical approach. I want to look at this very practically as per how compensation is going to operate in the court. Now, firstly, understand that what we have done here by giving a criminal court the ability to grant compensation, it is not novel, it is not new. It already exists in other pieces of law, right? So, for example, if we look at Section 30D of the Offences Against the Persons Act, you have a criminal court having the jurisdiction to grant compensation. Section 25 of the Summary Courts Act, you have that there. Section 4 and 4A of this said Sexual Offences Act, the court has the ability, a criminal court has the ability to grant compensation. Now, how does compensation and how will compensation work? Madam President, you're looking at a person has now been convicted of an offense. So you have been convicted of the offense, and at that stage of the conviction, at the point of sentencing, the court can ask the question to the parties available, to the parties present, to the prosecution and the defense. So tell me, what is your position on compensation? If the court does not raise the issue, then the prosecution can, of course, raise the issue of compensation. And it is at this stage, Madam President, that the court is now called upon to make that decision on compensation. But how is this decision? How does the court arrive at determining what type of compensation in criminal proceedings? How does the court determine this? Now, upon the prosecution, Madam President, making an oral application, as I would have earlier alluded to, the magistrate can call upon the prosecution to assist the court by disclosing documents that can be used to assess said damages. And again, to explain this, we have to look at the criminal proceeding rules. Madam President, if we look at Rule 3.5, for example, of the criminal proceeding rules, it says that each party shall actively assist the court in fulfilling its duty under Rule 3.1, whether or not the court has made a direction. And Rule 3.5.3 of the criminal proceeding rules also states each party shall make an appropriate arrangement to present any written or other material. So the criminal court, in other words, after a conviction is made, is now called upon, as I said before, to make an order on compensation. The criminal proceeding rules indicate how do we start this process? And the court can therefore, but pursuant to the rules, can make any other request from the prosecution and the parties available to present any evidence that would, of course, assist the court in coming to its decision relative to how much compensation ought to be given. Now, Madam President, one of the differences, though, in this particular bill that appears before us and other pieces of law in which a criminal court can grant compensation is that issue of a cap, right? So, for example, Section 24 of the Summary Offences Act, it speaks to the offence of fraud. This particular section, Madam President, it speaks to the offence of fraudulent conversion. And it says that a person liable under this section may also be ordered to pay the party aggrieved a sum not exceeding $2,000 by way of compensation. So, this is a criminal court and a criminal court that can grant compensation. But in the Summary Courts Act, there's a cap that is provided, meaning that a magistrate can't order beyond a certain amount, right? However, this bill that appears before us, there's not a cap, and that's not a bad thing. And the reason why I'm saying it's not a bad thing, Madam President, is because there are other guidance. For example, the Petty Civil Courts Act, Summary Courts Act, that allows the court, that gives this court, Madam President, the opportunity to decide on compensation based, of course, on the evidence that is presented. Of course, time did not permit me, Madam President, to address all of the issues that I would have hoped to speak about. But, Madam President, again, I wish to reinforce that I stand in support of this bill. It is good law, but certainly with the work at the select committee stage, I'm sure we'll be able to produce a piece of legislation that we will be proud of. Thank you, Madam President.